Good morning, everybody. I am Ian De Silva. Sorry, bear with us a second. Good morning, everybody. I'm Ian De Silva. I'm the Chief Operating Officer at the Canadian Support Workers Association and the Ontario PSW Association. Today, we're actually having a very special podcast with Varthan Arulsundaram, who is the staff lawyer. I'm sorry if I butchered your name, sir. Is a staff lawyer at the Mississauga Community Legal Services. So today, we're going to be going over a series of things which Varthan is going to be kindly go through with us. I'm going to give you a quick overview of who we're talking to. So today we are speaking with the Mississauga Community Legal Services, the MCLS, is a nonprofit community legal clinic funded by Legal Aid Ontario dedicated to providing free legal services to low-income residents of Mississauga. MCLS focuses on areas of law that significantly impact vulnerable people, offering services such as legal advice, brief services like letters and negotiation help, and representation at courts or administrative tribunals, though representation is subject to financial eligibility and capacity. The clinic's primary areas of focus include housing law, tenant, various social assistance, disability rights, limited immigration matters, employment law, workers' rights, and on and on. And Varthan has been a staff lawyer with MCLS and has been practicing in the area of employment law for more than a decade, and spent your entire legal career at various legal clinics helping vulnerable populations enforce their rights. Varthan, I can't think of anyone better suited to help guide our population in our community in this direction. There's a lot of questions we get, and there's a lot of knowledge gaps in this area. So I hope you can take it away, and well, we're in your hands this morning. So thank you for joining us.
Thank you. Thank you for having me. And thank you for that warm introduction. So I'm just going to share my screen and hopefully everybody can see it. I'm going to try and start this. There we go. Ian, can you see legal rights and responsibilities up on the screen?
I can see it. Yes, absolutely.
All right, perfect. So let me just. Whoops.
I think you want to.
Right.
Zoom's fine. There we go.
Perfect. Like Ian said, my name is Varthan. I'm a lawyer at Mississauga Community Legal Services. So the purpose of today's presentation is to try and give legal information for PSWs about what their rights and responsibilities are in the workplace. There's a few different types of key legislation that we'll go over, and sort of how to best keep track of your complaints, who you can complain to, and things like that. So Mississauga Community Legal Services is a legal aid clinic funded by Legal Aid. We help residents of Mississauga, but there's legal aid clinics scattered across Ontario. I think there's about 72 or 73 in total. Each serves their own geographic community, and then there's some specialty clinics that service specialized communities. For example, there's 3 WSIB related legal clinics that service Ontario. There'll be, if you are, of South Asian descent, there's a South Asian legal clinic. If you're of East Asian descent, there's a Chinese and East Asia clinic. So depending on your specific needs, there's different clinics that can assist you. While every legal clinic does, a different area of law, the sort of the core stuff that most legal clinics do are stuff related to tenant law. So if you're a tenant and you need any assistance, some limited immigration, if you have any problems with Ontario Disability, Ontario Works, EI, or CPP, then you can also get legal information or legal representation on those matters. I'm an employment lawyer, and so for the purpose of this presentation, it's going to be, entirely employment related. What we don't do is criminal law, family law, and refugee law. And again, there's the WSIB clinics for specifically WSIB related matters. So today's topics, right? So today what we're going to go over is sort of understanding the legal framework of rights for employees and specifically personal support workers. One of the main things that I've come across in my work is, the right to refuse unsafe work, especially as it relates to PSWs. Um, Disability accommodation in the workplace. So, if you've suffered a workplace injury or some other kind of injury and you need accommodations in the workplace, how you can go about that. Understanding the WSIB process, if you're a unionized PSW, and how you can effectively work with your union, and how you can document complaints and concerns properly. At any point as we're going through the seminar, feel free to put in any questions that you might have into the chat box. I don't know if I have control to be able to unmute mute people, but if you want to ask a question, you might want to put your hand up. Feel free to interrupt me as we're going through the process, or you can save your questions to the end.
Great. I'll also be monitoring questions as well. So if they come up, we have our chats here as well. So good to know. Thank you.
So understanding the legal foundations for PSWs in Ontario. So the main piece of document that governs your employment rights is your employment contract, right? So the employment contract will set out, what your pay is, how many hours you're going to work, what your vacation's like. So that is the main source of your rights as an employee. However, there's minimum rights that are set out by the Employment Standards Act. So the Employment Standards Act applies to all provincially regulated employees in Ontario. So it doesn't cover every type of employee or every type of work structure in Ontario, but I would say it covers probably about 75 to 80%. So some of the kinds of employment relationships that are not covered by the Employment Standards Act is if you are an independent contractor. So let's say that you are a PSW and you're incorporated, and then you provide your services to individual clients. In that circumstance, you don't have like an employment relationship. You're an independent contractor. So in the context of PSWs, you might have your own corporation or bill like a placement company, like a placement agency at the end of each month saying, okay, I went to these 5 home visits for these people, and so you owe me X amount of dollars. If you are in that kind of relationship where you're dealing with a bunch of different placement agencies and you bill them at the end of the month, you may not be an employee, but an independent contractor. And in those type of circumstances, you would not be covered by the rights in the Employment Standards Act, because the Employment Standards Act protects employee-employer relationships. Another type of, if you were a federally regulated employee, the Employment Standards Act wouldn't work. But for the most part, PSWs, as long as you're not in that independent contractor employment relationship, the Employment Standards Act will apply. And the Employment Standards Act, sets the bare minimum rights for, minimum wage. It sets the minimum for, how much vacation you're entitled to, how much severance and termination pay that you might be entitled to, when you're allowed to take breaks, that kind of thing. The second big piece of legislation that governs PSW rights is the Occupational Health and Safety Act. This act essentially covers your rights to be in a safe workplace and have safe working conditions. So it outlines the responsibilities for the employer about how an employer can make a workplace safe. And it also protects an employee's right to refuse unsafe work. Obviously, the safety of a workplace is very important for PSWs, because depending on the type of PSW work services that you're providing, there can be, things like heavy lifting. You're working with, violent or, like people who can't control themselves in the context of people like with dementia. And so having a safe workplace environment becomes very important, and how you can manage that and what your employer's obligation towards that becomes important and is governed by the Occupational Health and Safety Act. The next big piece of legislation is the Human Rights Code. So the Human Rights Code protects like all people from discrimination in the workplace with respect to, race, religion, ethnicity, country of origin, things like that. But the main piece that the code protects is with respect to accommodation in the workplace when you have like a disability. So the definition of disability is very broad, right? So, I have a bum shoulder because of a car accident I had 5 years ago. That's considered a disability, and an employer would have an obligation to accommodate that to what's called the point of undue hardship. So I'll discuss each of these acts a little bit, but the Employment Standards Act uh, is, is a very basic minimum rights. For most people, your employment contract will give you rights in excess of the employment standards minimums. Like, for example, you might be getting paid more than a minimum wage. You might be getting more than 2 weeks of vacation as a starting right. Um, but in no circumstance can an employer give you less than what's mandated by the Employment Standards Act. So the right to refuse unsafe work, right? So every employee, including PSWs, have the right to refuse unsafe work, right? So what is unsafe work can really vary from scenario to scenario, right? Climbing up a rickety ladder might be unsafe work that you can refuse. Um, Working with in the context of PSW, if you have to lift a very heavy person and the job requires two people to be able to properly and safely lift that person from, a bed to a bathtub or something like that. And let's say somebody called in sick and you're the only person on duty that day to you know, make that lift, you can refuse that as being unsafe work. And that's what's called a protected activity. So an employer can't take a negative action against you because you try to enforce one of these rights under the Occupational Health and Safety Act. So the right to refuse unsafe work, because again, could vary circumstance to circumstance, but you do have that sort of legal protection to refuse that work. So again, it becomes a very case specific situation for you as a PSW, because while you may think it's unsafe, uh, you know, at a certain point, if you can still refuse it if you believe it to be unsafe, whether or not it is actually unsafe in the circumstances. So, for example, let's say that you had to lift something that was 50 pounds and it did not require two people to lift, but you felt like you couldn't lift it and it required two people to lift, you could refuse that, right? Just because it's unsafe for you to be able to do. In these type of circumstances, when you do have like real concerns about the safety in the workplace, uh, you can file a complaint to the Ministry of Labor. So let's say, for example, uh, going back to my example about lifting two people needing required to lift somebody, if you find that your employer is not adhering to that standard about having two people available to make that lift, then you can file a complaint to the Ministry of Labor. So the Ministry of Labor would then investigate that complaint. And the Ministry of Labor is actually really good in responding to a complaint about an unsafe workplace. I've had clients call and make a complaint today, and then somebody from the Ministry of Labor is at the work site by tomorrow, right? So the Ministry of Labor does take these type of complaints very seriously and will generally send somebody to do a review very quickly.
We wouldn't have thought it'd be that fast, to be honest. That's a surprise.
I was surprised too when my client told me that, right? But they sent somebody the very next day.
Sorry to interrupt. Just needs.
Yeah, no worries. So how do you lawfully refuse unsafe work? So it's important that you report it right away, right? So as soon as you think that something that you're being required to do is unsafe, let a supervisor know, right? So let them know, hey, this requires two people. I don't feel comfortable lifting them by myself. You either need to assign somebody else to come and assist me, or we have to, delay this type of service to this client for the time being, right? And again, it becomes very case specific again about what the remedy might be in a circumstance where you've refused unsafe work. But the important thing is that you tell somebody right away, right? So if, again, back to my example about lifting two people to do the lift, if there isn't a second person, you shouldn't just be like, okay, I'm not going to do this and then move on to your next task for the day. You should report it. In circumstances where you think that a specific task is unsafe, it's not and even if that's your only task for the day and you think it's unsafe for you to do, it doesn't give you a right to just be like, okay, I'm not coming, I'm going to leave the workplace. You have to make yourself still available in case they want to retask you to do something else, right? So, you feel unsafe lifting this person because you don't think that you're strong enough because they're a heavy set person or something like that. They might say, okay, you know what, we won't have you doing this task, but we'll have you doing these other tasks within the, senior retirement home or something like that. And again, whenever you report unsafe work, either to your supervisor or to the Ministry of Labor, when an investigation does happen about as a result of your refusal of the unsafe work, uh, cooperate with any sort of investigation, right? So whether it's your supervisor that's trying to figure out, okay, how did this workplace become unsafe or this task become unsafe? Cooperate with them, whether it's the Ministry of Labor, if when they send somebody, you have to um, cooperate with the investigation. Not only you know, to give force to the actual complaint that you made, but also to make the workplace safer for other people going forward. So yeah, so I mean, workplace safety is a shared responsibility, right? So it's up to employees to report the hazards and employers to um, take action to protect the employees and the workplace. But it's never, one person's responsibility to the other person. It is a shared responsibility. The next is disability accommodation in the workplace. So the Human Rights Code is the piece of legislation that protects an employee's rights to be free of discrimination in the workplace. So, like I'm sure most people are aware about, you can't be discriminated against based on race, religion, ethnicity, that kind of things. And for most part, from my experience at least, you don't see, or at least it's not like obvious discrimination on those grounds, right? There's always subtle discrimination on those grounds, but you won't ever see it being very obvious. But obviously, when you feel like you're being discriminated against based on, age, religion, ethnicity, um, it's important to document it in the same way I'm going to discuss later on about documenting. But the most common reason why cases go to the Human Rights Tribunal is failure to accommodate in the employment context, and specifically failure to accommodate a disability. So, like I said, the definition of disability is very broad, right? So it could be anything that, whether it's, a physical infirmity or a mental health issue that prevents you from being able to do the uh, the main duties of your job without accommodation, right? So again, is you take the context of like a physical disability, I have a bum shoulder, I have a bum knee, I can't do this specific task without some sort of accommodation. That kind of activity is protected by the Human Rights Code. So the employer has to make uh, reasonable adjustments to help an employee that has a disability so that they can work in the workplace to the point of undue hardship. So the threshold is really undue hardship, right? So what is undue hardship? Because it can again vary by the circumstances. So a larger employer may have a duty to accommodate to a greater extent than a small employer, right? So um, just to work on an example, so you've had a slip and fall. You've broken your leg and now your knee is a bit wobbly, right? So your tasks used to be that you had to walk around the retirement home at night to just make sure that you know nothing's happening, people are in bed and there's no crisis. So that required you to walk for about an hour, right? But now, because of your bum knee, you can't walk around for an hour. You need to take a break every 25 minutes, right? You need a 10-minute break. So that is the type of accommodation an employer would have to give you, saying like, okay, you know what, you can take a break every 25 minutes or 20 minutes, so you can sit down to give your knee a rest and then start your walk around again. So that would be the type of accommodation that an employer is obligated to give you. But when the test becomes, of undue hardship, if, you know, again, taking the position of having a bad knee, let's say that your job required you to, or the accommodation you needed is that you could not do any more walking at all, and that was the primary role, then the employer might be able to say that they could not accommodate that kind of restriction, right? Again, it becomes very case specific, and that example might not have been the best, but I'm just saying that there is a circumstance where the employer can say that the accommodation that you require is not one we can provide without undue hardship.
Okay,
Um,
the company can't be made to go bankrupt to support one person, theoretically, like, that's what the goal is, right?
Yeah, right. And and even bankrupt doesn't even I wouldn't even say to that extent, right? But yeah, like if you needed an elevator put into your workplace because you couldn't take the stairs anymore, then yeah, that might be just too much of an undue hardship because it could cost them $100,000 to put in an elevator and they
Yeah.
don't have those kind of funds. So yeah, it is like, and the financial component is a um, a measure of what is undue hardship, but it's not the only measure, right? So again, if uh, if the accommodation you needed was that somebody had to be with you at all times, and they essentially had to hire another person to able for you to be able to do the essential duties of your job, that could also be like, that's not a feasible option. Or if because of your disability, you could no longer do, you know, 50% of what your duties were before, and you would just do, 50% of your role, that also might be undue hardship. But it becomes a very case specific. And from my experience, most employers, from the get-go, they will try to make the argument that, oh yeah, we can't accommodate that for X, Y, Z reason, but 9 out of 10 times they can, right? Because most times employees aren't making any unreasonable requests, right? They're usually making fairly reasonable requests. The employer, it's some cost to the employer, and the employer usually doesn't want to bear that cost. And that cost might not be like taking them bankrupt, but it's still a cost, and the employer sees themselves as a business and doesn't want to incur that cost. And
Mhm.
so that is a breach of the human rights code, right? That because that isn't the legal test under which the human rights code operates, but that is the approach you will see that most employers will try to take.
Seems like the easy way out. We can't afford it. We can't afford it. We don't
Yeah,
want to.
right.
Yeah.
And so there's lots of case law that basically says that employer can't just rely on the statement, we can't afford it. If they genuinely want to rely on the statement that we can't afford it, they actually have to show proof of that, right? So again, they would have to show like, okay, this is what the material cost is. This is how much it would cost us to do the renovations. This is our revenue, right? This is all we make in revenue per year. So, we can't afford to make this type of accommodation request. So they would actually have to financially be able to prove it. So that's why like larger employers, like if you work for like Chartwell, they would have a higher duty to accommodate, right? So maybe Chartwell can afford $100,000 to put in an elevator versus a small employer that runs a 10-person retirement home that might not have be able to put in an elevator. So, workplace accommodations isn't necessarily just a changing of your job duties. So, physical adjustments to your workplace or support equipment is a type of accommodation that an employer may be obligated to give you. So, if you're a PSW and you spend half your day in front of a computer, and your doctor has told you that you can't sit for more than 10 minutes and stand for more than 15 minutes because of a back injury, your employer would be obligated to get you a sit-up, stand-up desk if that's the accommodation that you needed in order to complete your job. So, like support equipment in order for you to be able to do your job, an elbow brace, wrist brace, an ergonomic keyboard, an ergonomic chair, anti-fatigue mats. These are all types of support equipment that and those are generally, relatively affordable. So from my experience, it'd be almost impossible for an employer to say, no, we're not going to provide you those type of support equipment. Um, but sometimes that's all the employee needs in order to be able to do the job that they were doing. Schedule flexibility, right? So depending on the type of, and this isn't only in the context of disability, but in other like, family status, that's also protected under the Human Rights Code. An employer might be obligated to give you sort of flexible working hours, right? So that might be, the employer might say, we need you here 9 to 5, but because of, I'm on dialysis, so I have to do dialysis once a week every morning until noon, right? So I can't start my shift until noon. So that's an accommodation for schedule that an employer would be obligated to provide. With the context of family status, I'm a single parent. I have to drop off my kids' daycare doesn't open until 8 a.m. So I can't come into work until 8:30, right? Like this is the accommodation I need. And so that is also an accommodation that the employer may be obligated to give. In the context of schedule flexibility, an employee does have an obligation to try and minimize the effect of the interruption or the disruption that the schedule might be. So, like if you have the option of getting a daycare that starts at 7:30 so that you could start at 8 o'clock, you might have that obligation to try to make that change. But there'll be circumstances when, something abrupt happens that you can't plan for, and that's when this type of schedule flexibility will also come in, right? Because if you have a doctor's appointment, you don't know when you're going to have your doctor's appointment. They call you on Monday being like, hey, we have an MRI available for you on Thursday. An employer can't be like, oh, you can't take that day off to go to your MRI or doctor's appointment. They would be obligated to allow you off without taking any sort of penalty against you for allowing that time off. The other way is also task reassignment, right? So if as a result of, let's say that 25% of your role was lifting people up and down, right? So, but because of your, shoulder injury, knee injury, or some sort of other physical disability, you're no longer able to lift more than 10 pounds or more than 20 pounds. So you can no longer do that task. The obligation as an employee is to just be able to do like most of the tasks that you were like in layman's terms, just most of the tasks that you used to be doing. So even though you're not able to do these tasks of your job duties, the employer may be obligated to just reassign you, right?
It,
So to
it sounds like it's trying to be like to show the employee and should show some good faith in trying to accommodate their own injury situation. Is that
Yeah,
okay?
yeah, right. And it's again, an employee should, because the right to refuse unsafe work also protects, is based on a client's disability, right? So if my restrictions are that I can't lift more than 20 pounds, I can refuse that unsafe work because they're asking me to lift 40 pounds or 50 pounds, right? So while again, you should act in good faith and try to fulfill your role as in your PSW role, whatever like your day-to-day tasks may look like. You're under no obligation to put yourself at risk um, to do whatever tasks that the employer might assign you. But that being said, the employer has not a right, but may ask to reassign you to do jobs within your restrictions. And then as an employee, you may be obligated to accept those tasks, right? Because again, because there's sometimes tasks that people don't like, but fits within their restrictions, right? Like like cleaning up after people, right? So while you may not be able to lift people, so the employer says, okay, you know what? We're going to take those tasks away from you, and we're going to give all the lifting tasks to John, right? But we need you to take over John's tasks, which include, cleaning things. And that might not be a job that you like to do, but unfortunately, if it fits within your restrictions, that's a task reassignment that the employer can rely on for accommodation purposes.
Okay, that makes sense.
So how should you make a request for accommodation? So the first thing is, communicating it to your employer, right? Saying that, hey, this is the disability or this is the injury I have, right? So an employee is not obligated to disclose the diagnosis, right? So you don't have to tell them that, hey, I have a tear in my shoulder, right? All you're obligated to do is provide what your restrictions are. That, because of my disability, I can't lift more than 10 pounds with my left arm. You don't have to tell them that it's because of a tear in your shoulder. For most people, like when it comes to a physical disability, most people have no problem disclosing that, hey, this is the injury I had, and this is why I can't do it. But there could be sometimes when it's, a sensitive matter that people don't want to, disclose it, especially if it's like a mental health issue that people don't necessarily want to tell them, hey, I'm suffering from postpartum depression or depression, major depressive symptoms or anything like that. They might just say, okay, because of the the disability, I need a 3 month leave of absence, right? And that the purpose of not having to disclose the disability is just to sort of protect your medical, uh, privacy. Um, but even with like physical disabilities, sometimes people are just embarrassed about how it happened or what it is, and you're under no obligation to disclose it. When you do ask for an accommodation, the employer is well within their rights to ask for medical information to support it. Usually, it's in the form of what's called a functional assessment form, where sometimes they'll just rely on whatever the doctor provides. Sometimes the employer, or I would say in most cases, the employer will have their own version of the form where they will ask the doctor to fill it out and return to them. So normally you'll, again, depending on the type of disability, you'll have a questionnaire and they're like, can the person lift how much can a person lift? Can they lift it above their head? How much can they stand for? How much can they sit for? And so the purpose of that is just to find out what the restrictions of the employee are and how the employer can accommodate that disability. So from the previous side, it's depending on the type of accommodation that you're looking for, the employer will try to find an accommodation for you. The accommodation does not have to be the employee's preferred accommodation. It just has to be an accommodation to meet the employee's disability, right? So back to the example of cleaning rooms. So even though that that there's work available in a clerical role for that 25%, and even though that might be your preferred accommodation, if the employer is like, no, well, we can put you for cleaning and that fits within your restrictions. So even though it's not your preferred role, the employer can still has met their duty to accommodate. Uh, and it is a collaborative process, the duty of accommodation, uh, because sometimes people will try an accommodation, it doesn't work, so people try and fail. The employer will try different things. The employer has a legal obligation to try to get you back to work. I mean, at the end of the day, there might not be an accommodation available for you, right? And at that point, it might just become an unpaid leave of absence or, an application for short-term or long-term disability or some other sort of disability provider. But there is often a back and forth process before the accommodation is either finally reached or the parties decide that accommodation isn't going to work in these type of circumstances.
Okay, great.
The WSIB, right? So WSIB is the workplace like injury program in Ontario. So basically, if you are injured at work, uh, you have the right to apply to WSIB for both things like income replacement if you miss time from work. And then depending on the nature of the injury, there's also like retraining obligations. So typically what happens is, I get injured on the job. There's a form that the employee fills and there's a form that the employer fills. You don't have to wait for the employer to fill out their form or anything like that. You can just fill out the employee form and sub it to WSIB. That'll get the process started. And let's say you have one of those employers that's loafing on providing the employer form to WSIB. WSIB will follow up with the employer to get them to submit the form. So the WSIB form, component is just sort of what happened. And you would sort of explain how the injury happened. And there's a component where you have like a doctor's form where the doctor fills out, I saw the patient for this and this is how I treated them. Uh, that application gets sent to WSIB and then WSIB makes the assessment. It's like a two-part assessment, right? First is the injury work related? And like what is the remedy for the employee? So 9 out of 10 times, it's very easy to prove that you've had a workplace injury because something traumatic happens, a slip and fall, you're trying to lift something heavy and throw out your back. But sometimes it could be something like a repetitive strain injury. So nothing traumatic happens. It's just, you're sort of doing the same uh, motion over and over again. And then as a result of it, you develop a bum shoulder, right? So those ones are obviously a little bit more difficult to prove because there's no like quick traumatic injury. And so WSIB makes the assessment about whether or not the type of job you were doing would have led to this type of repetitive strain injury. If they're satisfied that, the type of job that you were doing would lead to this type of repetitive strain injury, then you qualify for the benefits. So once you hit that stage where you qualify for benefits, WSIB makes the assessment about whether you need to miss work or not, right? Or whether or not you were justified in missing work, right? So let's say that you had a shoulder strain, right? And your doctor says, okay, you have to be off work for 3 weeks. WSIB says, okay, you know what? That's a reasonable amount of time for this type of strain. So we'll give you loss of earnings benefit for those 3 weeks. After the 3 weeks, you say that, hey, you know what, my shoulder still hasn't gotten better. I'm not going back to work. WSIB will then make the assessment about whether or not you should have a longer time period to rehabilitate, or they can say that you should, by 3 weeks, you should have gotten back to your pre-accident condition, and we're no longer going to provide you any benefits. So they cut off your loss of earnings. When they make a decision like that, that's an appealable decision, right? And then you can go through the whole process of appealing the decision with WSIB. But if let's say you have kind of injury where WSIB is like, okay, you know what, this is going to be a long-term injury, and um, but we think that you can go back to work if you have proper accommodations from the employer. WSIB will work with your employer and you to try and get you back to work with accommodations.
Can I ask you a question, Varthan? What workplaces related to PSWs does not pay into WSIB?
I don't think there are any, right?
All
So,
right. There used to be
I,
group homes. I know for a while back they did not do
uh,
WSIB, but I'm not sure if that's changed. So
yeah. So because this is a high injury type of role, like PSWs. So I would assume that all workplaces that deal with PSWs would. I had no idea about the group home exemption, but if that is the case, I don't know if that's changed or
I
not.
don't know either. It's just
Yeah.
it's okay. Sorry.
Yeah. So I would always just double check with the employer. But even if you don't know, just file the application to WSIB, right? Because WSIB will then make the assessment about whether or not the employer was making any contributions to the program, right? And then things. So the worst they can do is say no to you, right? Saying that this workplace was not covered under WSIB. Um, but because again, it doesn't cost you anything to make the application. So I would just say if you're unsure, make the application. But from my experience, I would say most workplaces for PSWs are covered by WSIB.
I think so as well. Thank you. It's just
No problem. So if the employer, if WSIB makes the employer try to accommodate you, they may only put the accommodation in place until they assess that you are back to your pre-accident condition. And then they could say, okay, the employer doesn't have to give you modified duties any longer, right? Um, at some point, WSIB might say, okay, there's no way for you to go back to this job, even with accommodation. So WSIB also has a retraining program where if they are satisfied that you are not going to be able to go back to your pre-accident job, even with accommodations, they could retrain you to do something else, right? So they'll put you to school, get you a diploma in something, right? Usually they're like 1 or 2 year programs to try and retrain you to do something else that would fall within your restrictions. A lot of times, though, WSIB just does deny people saying that you've reached your pre-accident condition or you had a pre-existing condition that made this all worse, so we don't have to cover you for that pre-existing condition. And that's when you have to go through the WSIB appeal process. The whole WSIB appeal process can take up to about 2 years. So the first stage is the WSIB has a caseworker, and the caseworker makes a decision about whatever it is that you're claiming for. the decision is a negative decision, and then you get 6 months to object to that decision. Once you object to that decision, it goes to there's an appeal process within WSIB. So basically, somebody else at WSIB looks at your case. Between when you're denied and when this other person looks at your case in WSIB might be, 6 months to a year. But during that time period, you can give updated medical information, right? You've gone to see specialists, you've got MRIs done, and there's new medical information that either supports your case or doesn't support your case. But you can provide that to WSIB and they will make a new decision. If the original decision is upheld, you can appeal that decision from WSIB to the WSIAD, the Workplace Safety Insurance Tribunal. The tribunal is kind of like a court, right, where you'll have like a decision maker who does not work for WSIB. They are considered independent, and they will review your medical evidence and any submissions you make and any testimony that you provide, and assessing whether or not WSIB made an incorrect decision. If they are satisfied that WSIB made an incorrect decision, then they can grant you benefits going back to when you were denied, right?
They
So
can
basically,
back pay you then, essentially.
yeah. So basically, I've had clients, who took a really long time to get to WSIA for whatever reason. They might have 2, 3, 4 years before they go, and WSIB has ordered that loss of earnings benefits be paid for that entire time period. Right. So it is retroactive in all cases because they basically WSIA says the original decision was wrong, so you should have all the benefits as if the original decision was made correctly. But again, that process takes a while. But just because WSIB, and again, from my experience, WSIB likes to turn people down, because at the end of the day, they are an insurance program, so they're not trying to pay people out. But just because they say that you're not entitled to it doesn't mean you're not entitled to it.
I think that's experiences a lot of people we encounter have with WSIB. It's that same thing.
But yeah, one of the things is you do have to promptly report any accidents or anything like that to WSIB and your employer right away, just because there is a 6-month limitation period. So if you have a workplace accident today and you wait a year to complain about it or file it, WSIB can deny your claim because you waited too long to report it. The main reason being just that, it's hard especially if it's like a traumatic injury, it's hard for WSIB or the employer to prove or disprove that it actually happened because you waited too long and the evidence might not be available to prove the claim or not. One thing also is that for filing a WSIB claim, you do not have to wait for your employer. Just even this morning, I had a client come in, they had a workplace injury, and they didn't file an application to WSIB because they thought that their employer would do it. So they were just sort of waiting, and nothing ever happened. And 2 years later, they couldn't do anything about it. So just because your employer says they will file the application doesn't mean that you have to just wait. There is a form for the employees to fill out, the form for the health practitioner to fill out, and a form for the employer to fill out. And it's important to get your form in because you'll get it in ASAP. You'll get like a file number and a caseworker signed and everything. So when you want updates, there's somebody to call and contact.
Okay, good to know. Really good.
So with WSIB, right? So even WSIB is, they don't work for the employer, so they are supposed to do an impartial evaluation of your claim. WSIB does have nurses on staff, so sometimes like your caseworker may not be a nurse, and they're usually not making a medical decision about something. It usually will go to a nurse practitioner or somebody like that, and then they make a decision or a recommendation to the caseworker who enacts that decision. Obviously, be truthful in your application, and because again, you can be denied benefits if like you're not believable, right? So there's a case a colleague of mine had where the WSIB found that the person was malingering, and then they had supportive evidence where they've like on Facebook and stuff where they were doing like they were saying they had a bad back, but then they were like doing gymnastics and things like that, and they could rely on that type of other evidence to be like, hey, this person does not have the injury that they're claiming.
So WSIB will look at your social media to confirm, or at least they have that right if it's presented to make an adjudication based on what they're seeing there. Okay.
That's right, right. And in that case, like from my experience, WSIB doesn't make an independent search, but the employer might, right? Saying
Well,
like
yeah, yeah.
this person's lying to you. Here's all this evidence that they're completely fine. But yeah, so like that is a reason that you can be denied. Um, Medical requirement. So WSIB, when you're on a prolonged like leave of absence from work for because of a workplace injury, WSIB can mandate things that you are required to do. And if you fail to do those things, you could lose your benefits. So, for example, like if they order retraining and they say, okay, we'll put you in to become an accounts payable clerk. So, we're going to sign you up for a Humber College 1 year program. And you're like, nah, I don't want to do it. Then they could cut you off benefits for failing to follow through with the retraining. Obviously, one of the things is you can refuse the retraining if it A, like what they're trying to retrain you in doesn't fit within your restrictions, or B, because like let's say it's you had a traumatic head injury and you can't sit in a classroom for more than 1 hour. So retraining becomes difficult. So you can say that, hey, I can't do this type of schooling because it doesn't fit within my restrictions. So then we'll be coming back and forth with WSIB to see how they can accommodate you so that you can be retrained. And again, there's also these return to work obligations that the employer has. So WSIB may again say that, okay, we've assessed these as your restrictions. We're putting you back to work at the same employer with these accommodations. If you're like, no, I can't, I don't want to do it, and WSIB can cut you off benefits again. And again, WSIB might put you back to work in a return to work program that doesn't meet your restrictions, and you can say no on that basis. But WSIB might still cut you off benefits, and you'll have to go through the whole appeal process to satisfy WSIAT that WSIB made the wrong decision by saying you could do the work with these accommodations. So next, unionized employees, right? So I have a lot of PSW clients that are unionized. So when you are with a union, basically only the union can represent you. So if you come to a lawyer and say, hey, I want to do this against my employer, the answer is going to be no, I can't help you. You have to go back to your union, right? So obviously the part of the union's role is to, negotiate the collective bargaining agreement that sets your rights with respect to um, what your minimum rights are in the workplace. So typically your collective bargaining agreement will be more than what's in the Employment Standards Act, but your starting point will always be your collective bargaining agreement. So unionized employees don't fall within the scope of the Employment Standards Act. It's because you guys have a different process in which complaints can be adjudicated. So again, when you have a complaint against your employer, it's typically a complaint that there's been a breach of the collective bargaining agreement. So when there's a breach of the collective bargaining agreement, the first step is to file a grievance, right? So the let's say, for example, uh, you get terminated because the employer found that you were late to work too many times, right? The first step would be to file a grievance. So depending on the collective bargaining agreement that you have, there'll be a set time frame in which you have to file a grievance. Um, each of your workplaces should have like a stop shop steward, right? Or a local rep that you can go to contact and basically get information about how you can file the grievance. Once you file the grievance, there's usually a process where you can try to mediate whatever the dispute is. So if it is a wrongful termination, the employer and the union will try to negotiate either to get you back to work, to pay you, lost wages, to pay you severance and termination pay, and they will try to come to some sort of agreement. If the parties can't come to an agreement, and obviously like the employee has a lot to say, like it's your right at the end of the day. If you don't agree with the settlement, you can ask the union to take the matter forward to arbitration. So you'll see this often in cases of dismissal for cause, where the employer thinks that they had just cause to terminate an employee, but the union and the employee say no, like that wasn't amounted to just cause. So a lot of times you won't be able to come to a settlement and it'll go to arbitration, and then the arbiter will decide whether or not the employer had just cause to terminate the employee. If the arbitrator is satisfied that there was no just cause, then the employee can get things like lost wages, reinstatement to their previous position, and sort of try to make them whole as if they were never terminated in the first place. But that's sort of like the normal process in which an employee can enforce a grievance with their employer.
So just to go back, and that's great information. So just to confirm, so if I'm in a unionized environment and I have a collective bargaining agreement and I interpret something as being a violation of the Employment Standards Act, I don't go to the Ministry of Labor. My first step is go to my union, and my only step is go to my union, right?
That is correct.
That's
So,
correct. Okay.
right. So, because I'm in theory, there should be nothing in the collective bargaining agreement that's a breach of the Employment Standards Act, right? So,
Right, which is why
if
it would.
yeah, but let's say that you think that there's something in the collective bargaining agreement that the employer is breaching. So let's say that um, you're supposed to get a 30-minute break every 5 hours, right? And for whatever reason your supervisor is not giving you the break, you can file a grievance about that, saying that your employer is not giving me my mandated breaks under the collective bargaining agreement. So a grievance can be filed for that. And that basically starts the process of the employer investigating what's going on and trying to provide the employee with a remedy. So in my example, the remedy might be that going forward, you'll get your breaks, and for, the 5 breaks that you missed, we'll reimburse you, whatever your hourly, like a prorated amount for the work that you had to do those times. But any breach of the collective bargaining agreement can generally be grieved.
So just a quick question, because sometimes this is rare, but it does come up, where you have a unionized PSW that has a complaint against, for example, their supervisor. But that supervisor is also a part of the union. It may also be the union steward. So that union steward decides not to bother putting any of this down on paper and just ignores it. What steps can the PSW take if they're not able to get to the union and the union is not following, because it does happen that stewards choose not to do this? What do they do then? Do they go to the Ministry of Labor and file a concurrent complaint? Is there?
No. So they have to escalate it within your union. So typically, depending on the type of union you have or are a part of, it may be a large national union, right? So you might be local, 136 of CP of the postal workers union, right? And
Right.
so each of these locals will have their own elected officials, right? So while your workplace will have a shop steward, there'll be a president, a treasurer, vice president, secretary of that local. So if you're not getting the remedy, or if your complaint is with your shop steward, who's your supervisor or something like that, then you would escalate it within the union, right? So you can go to your secretary, the president. If the local union is not addressing your needs, then I would escalate it to the next level, right? So there might be like a GTA wide union, right? And so you'd find the whoever the officials for that union are and escalate it. But you would not be able to bring the matter to the Ministry of Labor. You would have to escalate it within the union. At
Because, yeah.
some, yeah, but at some point, and I have this all the time, where clients are just like, my union is not helping me at all. Like they are not doing anything for me. And so there is an application that a union member can file against the union at the Ontario Labor Relations Board. So it's called the duty of fair representation, and say that the union is not fairly representing you on your matter, right? uh, I've never done that type of application myself, but apparently those applications are very hard to win, right? Because in most cases, unions are doing something. It's just the the member doesn't agree with the approach or doesn't agree with the outcome and things like that, right? But there's a process where if you think your union isn't helping you at all, that you can take the union to the Ontario Labor Relations Board.
Like it's ever gotten that serious, but just good to know. Thank you.
Yeah, and I also find a lot of complaints that I receive about members against their union is that they're not responding in a timely manner or something like that. The thing I always tell clients is like, this might be the only thing that you're dealing with, right? Like it's one matter for you, so thing, but a shop steward might have 10, 20, 30 of these type of complaints that they're juggling at the same time, along with their 9 to 5 job, right?
Yeah.
The shop steward isn't, that's not their only job, right? They're doing their 9 to 5 plus whatever other union work that they're doing. So sometimes it can just take a little while. And like the whole grievance process could take a very long time, right? So they might have no update for you, and it's just a matter of waiting till there is an update before the union contacts you, right? So, um,
Thank you for saying so, because I think that's a really important point that I think a lot of people forget is that we're a little self-centered with our own problems. So we do have to be mindful about expectations from those who have to deal with many. Yes. But thank you for saying so.
yeah, and a lot of times it's just there is no update available,
Which
and
is yeah.
yeah.
We live in a time where everyone wants instant gratification. They want it now. They want everything right away, but we have to still wait.
So yeah, we spoke about this. So when you need to access union support, contact your local rep, right? The one that's in your workplace. They might be called the shop steward, local rep, representative. And then if you're having difficulties there, you just keep escalating it within your union until you can find somebody that'll be able to assess your thing. And it's always important for people to be involved with their union, right? Because I have a lot of people that are part of a union and have no idea what's going on with the union. So I do recommend that people, stay in the loop. And it's good because you'll know like who your rep is, because lots of times people's reps change because there's like elections. It might be every year, every 2 years, something like that. They might have a rotating reps. And obviously you want to know who your rep is so you know who to go to when there's complaints to be made.
That's a good point.
So yeah, so the collective bargaining agreement is different from person to person. I'm sorry, from union or from workplace to workplace, right? So uh, you could be like one workplace might have one set of terms and one set of deadlines, where another collective bargaining agreement could have a different set of terms and a different set of deadlines. You should get a copy of the collective bargaining agreement every time a new one is reached. Usually they're good for like 3 years. And it'll outline what your rights and responsibilities are within that collective bargaining agreement. Um, so
Yeah.
next is documenting complaints, right? So this is usually the most difficult thing that comes across my desk is people wait for a very long time before they're ready to make a complaint, right? It's just it's going on for so long, I'm just fed up now, and then they're coming to get some sort of remedy. And the first thing I have to ask them is like, give me details about what happened, right? And so as a lawyer, like I'm always thinking, okay, I got to go to court over this. I have to convince a judge. How am I going to convince a judge that this is true? Right. So a lot of times people will have complaints because it's dated because it might have been 6 months ago, 8 months ago. They can't, remember specific details. They can't tell who was there. They can just be like, oh, so and so, said some really mean things to me. Like, what did they say? Right? Just mean things, right? But that's not going to be good enough in a court of law or in a tribunal or something like that. And it's important that the the facts of what happened are clear because the employer also needs to know it so they can have an opportunity to address it, right? So one of the things I always tell clients is start keeping a track of all your complaints as they're happening, right? So, if you've run into a problem with your supervisor today, just email yourself being like, hey, on October 13th or October 14th, I met with Jane. She started yelling at me because I didn't do this. I tried to explain to her that it wasn't my role, that it was Jack's role. Mary and Luann were there. They heard everything that she said, and this is exactly what she said, right? Even though you may not do anything with that specific complaint, if you think that it's becoming part of a pattern, it's good to have a record of it because at some point you need to complain to the first step is to complain to your employer, right? It might be HR, it might be a supervisor, but you have to go to them and be like, hey, this is the things that I'm facing in the workplace. I need you to do something about it. And the employer is going to want to ask about specifics. So that's when you can have this and be like, this happened on October 14th, this happened on this date, these are all the witnesses, because the employer has an obligation to do their own investigation before they take any sort of remedial action against the person you're complaining about. Because obviously, the person you're complaining about has their own rights with respect to employment, and the employer can't just take anything that you say on face value. They have to investigate before they take any sort of remedial action against that person.
So if you're in an environment and you just started working and someone yells at you, you should make an email just to draft an email saying this person was.
Yeah, and you can just send that email to yourself, right? The reason I say sending it an email to yourself because it's time stamped and everything like that. So the note is taken contemporaneously with when the incident happened, right? But at the same time, like every employee has the right to be free of harassment in the workplace, right? So if you feel like, because there's one thing for me as a supervisor to tell you, hey, go clean the bathroom, like you're late, you're running late, right? Versus you stupid person, like I can't believe you're so late, go clean the bathroom, right? There's a distinction, right? And sometimes like just telling you what to do because that's their role is different than harassment, right? And so a single incident of harassment or the way a person talks to you is enough to complain to management about. But I do think there's a distinction between what is and isn't harassment. And I think you as an employee just has to play it by like, because again, it's how you feel about the conduct towards you, and you can file a complaint. And at the end of the day, the management might say, you know what, we'll make sure she doesn't talk to you that way again. And that might be all the remedy you're getting. But at the end of the day, that's all you're trying to do is make sure your working circumstances, your working conditions are one that's fair and free of harassment.
Exactly. That's a
Uh,
huge problem with PSWs, I think. And there is, if I can just jump in quickly, I think there's a lot of disconnect about what is and what is not harassment, what is and what is not bullying. And I think we try to cover as well as an association, getting directions from your employer, even if in a firm tone, it's not bullying or harassment, it's a direction. If they start using derogatory terms, like you said, and it becomes pattern, that's absolutely harassment. So there's a very defined line there.
100%, right? So I think you hit the nail on the head, right? Again, uh, at the end of the day, all you can do, if you genuinely do feel harassed, you should file a complaint, right? And it might just be that you don't get the remedy that you're looking for because the employer is not satisfied that there was harassment, but at least you've put it on the record and it's out there, right? And I would say from my experience, 9 out of 10s, you will get some sort of improvement in your working conditions because the employer might just say, hey, like to the offending party, hey, like try to minimize your contact with her if you can so that this isn't an ongoing issue, right? And that might be a good enough remedy that it improves the working conditions.
Sometimes people don't know that they've raised their voice too. It's rare, but it does happen. So if they're told, they become more self-aware of what they're doing, which is not a
Yeah.
bad.
And I've had clients that are loud talkers, right? Are very animated, right? When they're explaining something. And for a third party watching it, they might think that this person is angry with me,
Yeah,
but they're not.
right.
That's just the way they talk, right? So, but again, very fine line, very case specific, and people should do what they feel is important in the moment.
Completely agree.
So yeah, like keeping clear records, date all the dates of complaint, keep clear records. Again, I always say email yourself because it's timestamped, but clear records is important.
You're right.
Uh, so normally, before you jump to any sort of external reporting options, like filing a complaint with the Ministry of Labor, Ministry, Ontario Labor Relations Board, the first step is that you do have to follow internal channels to try and remedy the situation. Obviously, there might be some circumstances where your issue is with the owner of the retirement home or something like that, and so there's nowhere for you to complain to. I always still recommend people to write to that person. Like if there isn't like the top of the food chain is who you're trying to complain about, still write something to them. But in some circumstances, like the Ministry of Labor will want to see that you've complained to the employer to see if they'll remedy the situation before they, you know, do an investigation or get involved.
Fair.
Right. So that takes us to the end of our presentation. I know there was like a lot of information
There's
thrown
it's
out
great.
there.
No, that was
Right.
great.
Right. But one of the big takeaways I want from, like, aside from the legal rights component, is there are free legal services available to employees and PSWs. So if you have a question about like your specific working conditions, feel free to reach out to your local legal clinic. If you Google legal clinic postal code, there'll be on the Legal Aid Ontario website, there's like there's like a gadget where you just put in your postal code and it'll tell you where your local legal clinic is. Obviously, if you live in Mississauga, feel free to give us a call. But if you live in other parts of Ontario, because I understand that people are checking in from all parts of Ontario, that check in with your local legal clinic.
Absolutely. No, that's good to know. I think a lot of PSWs aren't sure if they're eligible to approach it. And what is the income threshold? Did you know that for
Yeah.
legal?
So for like it's based on the number of people in the household, and it's based on household income. The legal aid threshold is pretty low. I think for like a single person, it's about 25 to $30,000. And then it increases incrementally based on the number of people in the household.
So if you're a single mother with three kids, you might be able to make more money and still get legal aid.
That's correct.
You're single. Okay, that's just good
Yeah.
to
And most legal clinics will give summary advice for free, right? So you can get the summary advice regardless of income threshold. It's only if you need representation, like at small claims court, Ontario Labor Relations Board, that kind of thing, that uh, you may not be able to get the free service from Legal Aid Ontario.
know. Okay. I'm not sure if we have any questions coming in the chat. It doesn't look like it. I think people were kind of just taking notes throughout this whole presentation. There was a lot of great information you provided, and it's really interesting, especially to know that and encouraging people that you're a part of this environment. As an employee, you do have a duty of care to your employer, and the employer has a duty of care to yourself. We rarely see this, but there's always bad eggs, both employers and PSWs, that employer and PSWs try to take advantage and say, I want to just get paid to do nothing. That's very rare.
Mhm.
It does happen, and employers want to get a lot of work and pay nothing evil. So it's a balance. So Varthan, I really want to thank you for taking the time to come in and present this to all. This is going to be recorded, so if you're okay, it's going to be on our database, and especially the information about providing access to legal clinics. PSWs are, I think there's a lot of knowledge gap in how they can get assistance, where we can go. Even as an association, sometimes we have conflicting information on how to direct people, but this has been extremely important to this morning. So I do thank you so much for coming again. Um, so I don't think we have any questions. It looks like everyone's kind of stunned with the information, so we appreciate it. Um, and again, I hope maybe in the future you can come back and talk to us again, because we are always looking at bullying things, and we'd always love to have you come back and discuss
Uh,
anything you like. Are you
yeah, I'm happy to come back.
okay? Everyone, well, thank you so much, Varthan. Very nice meeting you, and thank you for the Mississauga Community Legal Services team, and you guys do great work. And well, hopefully you don't get overwhelmed with business. I hope not.
Yeah. All right.
Well,
Thanks so much.
no
All right.
problem. Great.
Take
Very much.
care.
Take
Bye
care.
bye.
Bye bye.